are in listen-only mode.
Welcome everybody to the line. My name's Chris Whatley. I'm the Washington Director of the Council of State Governments, and I want to thank everybody for taking time out of your busy afternoons to focus on what I think is one of the most critically important topics affecting states, the nature of the state-federal relationship and how that's impacted by this era of austerity we're living in. And I can say that the timing on this could not be any better. As I sit here on Capitol Hill in Washington, I'm watching the vote right now in the U.S. House of Representatives where they're voting on the budget compromise to fund the federal government through the end of fiscal year 2011, kind of that shutdown averting deal that was negotiated in the wee hours of Friday night to prevent the shutdown. And certainly the budget compromise that is being debated right now has huge state-federal dimensions. You know, we've gone from this period over the last 2 years with the Recovery Act, with the extension of enhanced Medicaid match and education funding last August, where the federal government essentially moved $160 billion worth of liability off of the state balance sheets and moved it onto their own balance sheets. Well, that era's ended. We're now into the point where all of the proposals out there, whether it's the proposals for the next budget year or the clawbacks in grants and aid that are being considered in the budget compromise right now, are all about limiting the amount of funding that's flowing through the state-federal relationship. And meanwhile, we've got health reform and the constitutional challenges to it that are out there working their way through the court system. So this is a dynamic period in the state-federal relationship, and we are really privileged today to have two of the best legal minds out there to help us kind of navigate this challenge, to look at where the state-federal relationship is going, and to field your questions so that we can start thinking about how these constitutional issues, how the structural issues in the state-federal relationship will ultimately play out in state budgets. And our two panelists today are, first of all, I'd like to say they're both Yaleys, and we'll forgive them for that fact. They were both educated at Yale. We've got Professor Jim Blumstein from Vanderbilt, who's one of the nation's top health law experts. He heads up Vandy's Health Policy Center. And certainly, when we talk about state-federal relationships, health policy really lies at the core. It's the tip of the spear, both in terms of the programmatic and budget flows to the states, but also of the constitutional questions that we're debating today. So we're just delighted to have Professor Blumstein with us. We also have Professor Roderick Hills from NYU Law School. And Professor Hills has a broader perspective on decentralization writ large as it plays out in the state-federal plane, but also in terms of within states and how decisions affect the local level as well, which is an area that sometimes we forget, but is increasingly dynamic as states kind of pass on their budget challenges, those other jurisdictions within states. So with that, I will turn it over to Professor Blumstein. I want to thank both of our panelists for being here. And for all of you who have questions, I encourage you all to submit them through the GoToMeeting platform here. And at the end, we will have plenty of time to field your questions. Thank you, and I'll turn it over to you, Professor Blumstein.
Thank you, Chris. I appreciate your kind words. I always love to be over-introduced. As I've told the organizers, I have spoken to live audiences where there has also been streaming. This is a new first for me to speak only to a streaming audience where there are no live bodies in front of me. And as a law school lecturer, I don't know if I can get this right or not. It reminds me of a story I saw on Jay Leno some years ago about this fellow in California who had a swimming pool, and he had a friend from overseas, and they were skinny dipping in the pool when a woman walked by, and the American got out of the pool and put his towel over his middle, and his friend from overseas got out of the pool and put his towel over his head. And when the woman left, the American was a little incredulous and said to his foreign buddy, he said, what were you thinking? Why did you put your towel where you did? And his friend from abroad was equally incredulous. He says, you know, I don't know about your customs in America, but in my country we're recognized by our face. And so you'll have to decide at the end of this whether my towel is in the right place or not. Nell, can I ask you to move to the first full slide, please? And this is the overview of the presentation. There are really three major themes that I want to present. First, I want to describe cooperative federalism, how it works, what its underlying rationale is, and some of the risks, both the federal and state governments that accrue from this form of program structure. Then I want to talk you through some of the basic constitutional issues and structural issues of constitutional law that govern federalism and cooperative federalism. And then for my third point, I want to apply some of those principles from the first 2 points to the current state challenge led by Florida to the Affordable Care Act, and specifically the expanded Medicaid mandate. In my view, I think that this is the hidden issue in the Affordable Care Act. It's part of the case, but it has not gotten much attention. I think it deserves greater prominence in the conversation, and I will talk you all through the issues as I see them. Can I have the next slide, please, Neil? And then the next one after that. Cooperative federalism and how it works. Basically, cooperative federalism is a federal-state partnership with federal funding that matches state expenditures. So the states put in $1, and when they get approval, it gets to be $2 or $3, in some cases even $6. But that's the nature of it. Now, states apply for these programs, they apply for funding, and they apply voluntarily. And as I'll explain in the constitutional discussion, it's a constitutional requirement that this participation on the part of the states be voluntary. But states seek out these programs and seek to participate. The federal government then approves the state's application, the state's plan, and as in cases like Medicaid, automatically matches. It's what we call open-ended matching the state spending under a formula. And this describes Medicaid and some other programs. There are some different models which are not as troubling and which I will not be talking about, and the Children's Health Insurance Program that was really born of a bipartisan agreement between Senator Hatch and Senator Kennedy when he was alive in the 1990s are different because they are not open-ended or automatic matching. They have a fixed federal allocation to a state based on a formula. As I understand it, this was Senator Hatch's insistence, and so that's a different type of a program than the open-ended or automatic matching programs such as Medicaid. I'm going to be focusing on the open-ended programs such as Medicaid. These programs, once they're entered into and agreed upon, have an ongoing relationship. This is not a one-off proposition. This is not typically the kind of program that says we, the federal government, will give you a certain amount of money to build a building, and that's the end of it. These Medicaid in particular is an ongoing relationship, and that has importance for what I'm ultimately going to conclude about the Affordable Care Act. Under traditional norms, the federal government establishes the ground rules or the parameters for spending. If they provide money to states to teach history, the states cannot teach biology. So there will be federal rules and regulations about what services are covered and who's eligible to receive the funding under the program. Now, and Medicaid here again is the model. Federal regulations typically allow states some flexibility in determining first the range of services that are covered. So in Medicaid, for example, there'll be certain mandatory services that are covered, others that are optional. And then typically second, the federal regulations will define a floor and a ceiling, a minimum number of folks, beneficiaries who have to be covered, but and a ceiling. But where between the floor and the ceiling the states are is up to the individual states. So those who are actually enrolled within these programs are above the floor, below the ceiling, but where within that area of flexibility is determined by state policy and state political decision making. Now, can we have the next one, please? So what are the benefits for the states from this type of cooperative federalism? The classic example is that this provides enhanced choices or options for states, because these provide the opportunity to have services or benefits for state residents that states might not be able to afford on their own. Basically, these cooperative federalism programs provide access for states and for their beneficiaries to additional resources and program benefits, but there's a limit, and the limit is that the states have to contribute a certain amount of money, which will be matched, but there's a sense of restraint that the states have to at least come up with their portion of the program budget, and this is a type of co-payment requirement and is designed as a built-in constraint on the state's ability to just run these programs up to max without some buy-in or participation. What I call the bitter with the sweet is that in order to receive the benefits, the extra resources, the states are obliged to accept the federal terms and conditions that are attached to the receipt of federal funds. So, and the courts have been very approving of the ability of the federal government to set terms and conditions that are attached to the expenditure of federal monies, on the theory that if the states are not required to participate, but if they choose to participate, then they cannot teach biology when the federal government wants them to teach history. Next, please. From the federal government's point of view, there are also benefits. This is a way of implementing or achieving federal priorities, and it establishes federal program leadership, and it allows the federal government to implement these federal priorities by building on, in some cases existing, but in any case on state administrative and political infrastructures. Sometimes they're existing, sometimes they're developed or enhanced to administer these programs. It encourages state buy-in and political support through these investments, and it does so with very favorable federal financial incentives to states. It's a way of leveraging federal money because these programs typically require substantial state expenditures, and so the federal government is able to achieve its goals by using state resources and building upon state infrastructure. Next, please, now. Now, what are the risks to the states? First, I want to talk about political moral hazard. Moral hazard is an insurance term. It's not used typically in the political context. But moral hazard basically is this principle. It's easier for me to spend your money. And moral hazard means that I'm more likely to engage in spending if I am spending a little bit of my money and a lot of your money. This is basically the nature and the structure of these cooperative federalism programs, that if I can spend $1 of my state money and receive 2 federal matching dollars, then under traditional cost-benefit notions, I'm willing to engage in a program if it's only worth $1 to me, and I'll be receiving 3 program dollars. So things that are maybe lower priorities get funded because of the attractive incentive system. Now, the incentives create tremendous opportunity, but also risk of program expansion by states. The political argument is, and I've seen this in Tennessee and across the country, how can we leave money on the table? We have to kind of max out our bank account here, and it always reminds me of walking down in a mall and seeing a 50% sale on a suit that I love, and you know, I'm leaving some money on the table. I'll never be able to buy that suit again at the attractive 50% off, or maybe 60% off, and it's very enticing to go in and buy that suit. But I still have to pay the 40 or 50% cost, and if it's an expensive suit, I may not even be able to afford it at a 40% price or a 50% price, and yet it's very attractive. So the argument always is, if you don't buy this, you're leaving money on the table, and it has a great political appeal. On the other hand, what I call the problem of receiving Bill Gates' house problem, and that is this. If Bill Gates, who has a $30 million plus dollar house with more than 20,000 square feet, I'm told, what if Bill Gates were to give me or you or anyone listening to this his house with a condition that says if you receive the house free, you have to pay the property taxes, you have to maintain the upkeep, you have to mow the lawn. If there's a problem or storm damage, you have to pay for that, you have to insure it. Great deal. You're living in a 20,000 square foot house. It's worth more than $30 million. It sounds like a wonderful deal. All you have to do is pay the taxes and the upkeep and the maintenance. But it may be that the maintenance and the upkeep are so expensive that a good deal is just too expensive to accept. Just like walking down the street and seeing an attractive suit or clothes or furniture or something that is too pricey, even at the sale price. Now, there's a risk to the states of a mandated program expansion that's imposed by the federal government after states agree initially to participate in programs such as Medicaid. And so we've seen that in the Medicaid program. The history of Medicaid is that the federal government has raised the floor in a variety of ways, and this has a significant effect on the state costs of participation. And from a more theoretical point of view, there's a risk of displacing of political accountability with the federal government driving state expenditures after the states initially decide to participate. And so you have this kind of whipsaw where the states are driving the federal government as the states expand. Then if the states decide not to expand or contract, Medicaid, the story of Medicaid was that the federal government raised the floor, and then the federal government is driving state political decisions. And so ultimately there's an upward ratchet and a risk of different political institutions driving the budgets of other political institutions, states driving federal budgets or federal government driving state budgets. Then there's the observed lock-in effect that comes from the nature of these programs that creates a state-level political dependency. What I call a political narcotic effect. States get addicted to these funds. Once they're in place, they build up political constituencies, not only of beneficiaries, but service providers as well. In Medicaid, it's not just the beneficiaries, but it's also the doctors, the hospitals, pharmaceutical companies, medical device suppliers, nurses, who are all dependent upon these dollars and these programs. And that makes it difficult to reduce or to eliminate these programs because of the fiscal pain of withdrawal. It's just a matter of arithmetic. On the way up, it's easy. $1 of state money brings in 3 program dollars if it's a 2-for-1 match. But on the way down, you're only saving 1 state dollar and you're losing 3 program dollars. That's an excruciating problem. And we faced that in Tennessee back 7 years ago when Governor Bredesen was doing this, and I was working, I was retained to help him work our way through this. And so at that point, basically the bait and switch problem arises because it's an impetus, and we saw this in Medicaid for the federally mandated program expansions to kick in when the states are deciding that their share becomes too burdensome. Next slide, please. Now, the risks of the federal government under the automatic matching program or the open-ended matching is that, as I've said, the state program or the expansion of the state program drives the federal budget. This is the other piece of that displacement of political accountability that I described earlier. There's a strong incentive on the part of states to drive up program costs, at least at the beginning, and federal costs are driven in large part by state political choices. This is the other aspect of the displacement of political accountability. And as we've seen in Medicaid, there's a strong incentive for states to engage in game playing by raising funds in ways that eliminate the restraint of co-payments, of requiring that you at least raise taxes or displace other state expenditures to provide the state expenditures that are matched by the federal government. In Medicaid, this was achieved by these Medicaid provider taxes. Many of us thought that those were eliminated 20 years ago in federal legislation, but that legislation had some, I guess you would call them loopholes or exceptions, and we're seeing the reemergence of these provider taxes, not as grossly as before, but I know in our state in Tennessee, the hospital industry sought to be taxed so as to raise more money and put some of that money into the state match, and that, of course, eliminates or reduces the restraint on state ability to fund its share. Now, program advocates may see these risks as advantages. There are ways around budgetary resistance to increases in program expenditures, and I think we see a lot of the structure of these programs that displace political accountability actually designed because program advocates see these as advantages and ways around resistance to programs that they believe to be valued. Now, next slide, please. Now I want to turn to the constitutional basics, and as I indicated earlier, one core principle is that states must be allowed to decide knowingly and voluntarily whether or not to participate in a cooperative federalism program. This is called the Anti-Commandeering Principle. The Supreme Court articulated this 19 years ago, nearly 20 years ago, and it protects the states from involuntarily participating in a cooperative federalism program. The federal government can financially induce states to participate or pejoratively bribe them to do that, but the federal government cannot mandate state participation. So the state involvement, at least at the outset, must always be knowing and voluntary, and states cannot be forced by the federal government to participate. So the court has said for years that this inducement cannot cross the line into coercion. I'm working on that as part of a project I'm doing. I don't plan to discuss that now. If in the question and answer people want to talk about coercion, that I'll be glad to talk about it. That for me is still a work in progress, and that's still a work in progress, and it's not something that I really want to include within this discussion. Next slide, please. The relationship between the federal government and the states in these cooperative federalism programs is governed as a general matter by principles of contract law. And that's important. And this is a principle that goes back to 1981 in a case called the Penner's case, so it's been with us for 30 years. The Supreme Court recognized in the mid-1980s that programs such as Medicaid are contractual in nature, but these are ongoing contracts. This is not the provision of widgets at a date certain and a certain amount. These have an ongoing nature to them, what's called in contract terms relational contracts. That these are relational contracts that are part of the fabric of contract doctrine. Now, under conventional contract doctrine, there's a significant difference between what a party can do at the time that a contract is formed or contract formation, as opposed to when an ongoing contract is modified, the so-called contract modification stage. There's a risk of excessive leverage at the contract modification stage that the law of contract recognizes, and there's a duty that's imposed to parties to an ongoing contract of fairness that does not exist at the contract formation stage. Next slide, please. Now I want to talk about the clear statement rule. This is a rule that governs these cooperative federalism programs, and it says that the terms and conditions of these programs, such as Medicaid, must be spelled out unambiguously or clearly stated so that states, when they decide to participate or not to participate, can knowingly make a choice regarding participation, and then this quote comes from the Penner's case, cognizant of the consequences of their participation. So they have to be aware of what's at stake, and they have to be, the conditions have to be stated unambiguously and in advance. Because knowing acceptance by states, which is a constitutional requirement, conditions that attach to these federal spending programs is a cornerstone of the constitutional legitimacy of these spending programs, that states have the right not to participate. They have autonomy interests in the integrity of their budgetary and political process, and while they can be induced to participate, that inducement has to be on a fully informed, fully disclosed basis so that they know what they're in for. And the Supreme Court has said that knowing acceptance cannot exist unless states are aware in advance of the conditions that are being imposed on them when they choose to participate in one of these cooperative federalism programs. Now, next slide, please. And the Supreme Court has said basically that states can only knowingly accept conditions that are imposed as part of these cooperative federalism programs if they're aware of those terms, and if they can, and the term they use is ascertain what the requirements are, what the conditions are at the time they decide to participate. Now, the court in the mid-1980s, in one of the Bennett cases, Bennett versus Kentucky, said that implied conditions can satisfy the clear statement rule if they are foreseeable and if they comport with community standards of fairness, so that you don't really want to have the federal government hamstrung so that they can't make reasonable and foreseeable tweaks to the programs. But the proper perspective for determining this and for making this assessment is that of the state official, who must decide whether the state should participate in the cooperative federalism program or not. That state official must, and this comes from a 2006 case, the Arlington case, must clearly understand the obligations that are being undertaken by the state when it chooses to participate in the program. So the perspective is the state perspective. What does the state official clearly understand when he or she makes a commitment on behalf of the state to participate in one of these programs? They have to understand what and be able to reasonably foresee what those terms and conditions are. Next slide, please. Now, what about the timing of this? Raises the issue of what is the proper timing of the clear statement obligation that is designed to protect the integrity of the state political process. Does it accrue at the contract formation stage or at the contract modification stage? Remember, the court has held for 30 years that we should use contract principles to determine these relationships. My sense is, and I think that while the court has never explicitly dealt with this question, the court has certainly talked about allowing states to determine whether knowingly to accept obligations that accrue from participating in one of these cooperative federalism programs, and therefore the clear statement obligation should apply at the contract formation stage when the states choose to accept Medicaid and to participate or enter into that program. If you apply this clear statement obligation at the contract modification stage, this allows the federal government to perform what's essentially a bait and switch, setting a low standard of obligation at the contract formation stage, and then through contract modification, raising the bar once states are locked in to a program, once they have this political addiction and have exercised their program expansion through what I call political moral hazard. We have to remember that this clear statement rule is not just a matter of discretion. The court has held that it has a constitutional foundation. It respects state autonomy and the state's right to decline to participate in a cooperative federalism program. It retains that autonomy under this anti-commandeering principle I described earlier. Next slide, please. Now. All right, how does all this apply to the existing challenges, what I've called the Achilles heel of the Affordable Care Act, or the ACA, and specifically applying to the expanded Medicaid mandate of the ACA? I'm going to draw a distinction between traditional Medicaid and then new Medicaid, which is the program as envisioned under the Affordable Care Act. Under traditional Medicaid, provision of services was linked to initially aid to family with dependent children, AFDC, now temporary assistance for needy families, or TANF, but basically it was a poverty medicine program. Medicare, enacted at the same time, targeted beneficiaries of Social Security Medicaid-targeted income beneficiaries of traditional welfare programs. Under the Affordable Care Act, federal premium subsidies are provided on these new state-based exchanges for all persons with incomes from 100 to 400% of poverty. But strikingly, and this relates to the coercion point, which I'm not going to develop today, but I'll be glad to answer questions on it. There's no federal premium subsidy on these state-based exchanges for persons with incomes under 100% of poverty. And I would argue that this is not an accident. That basically the federal government in the Affordable Care Act doesn't really contemplate that states will not continue to participate in Medicaid. In fact, they're so certain of it that they chose not to subsidize with federal funds the neediest and most vulnerable citizens of states, those who have incomes under 100% of poverty, at the same time that the federal government is introducing new subsidies on persons with incomes from 100% to 400% of poverty. So this notion is that Medicaid is, and the expansion of coverage under Medicaid is built into the very architecture of the Affordable Care Act, and about half of the 30 million new beneficiaries of medical insurance contemplated under the Affordable Care Act come from this expansion of Medicaid. About 15 million people is the estimate. So under new Medicaid, the conditions under the ACA, states are required to include persons with incomes under 133% of poverty. And if they don't, they're excluded entirely from the entire Medicaid program. Next slide, please. No. The Affordable Care Act imposes conditions on Medicaid that are in the nature of contract modification. You recall I drew the distinction between contract formation and contract modification. Medicaid is an ongoing program, a relational contract, a very special kind of contract, and this is a modification of the terms and conditions of that relational contract, of that ongoing contract. The contract formation stage with respect to Medicaid occurred when a state chose to participate in Medicaid. Next slide, please. And so my view, again, is that the ACA imposes conditions on Medicaid that are in the nature of contract modification. In order for a state to be, and this is a quote from the Penrose case, I believe, to be cognizant of the consequences of its participation in Medicaid, it must be aware of and be able to ascertain the nature, scope, and magnitude of its financial obligation. Congress has power to impose conditions on these cooperative federalism programs such as Medicaid, and this again is a quote from the Penrose case, does not include surprising participating states with post-acceptance or retroactive conditions. That is to say, you can't do bait and switch. That these clear statement obligations must arise when states are making the crucial decision whether to participate or not, at least with respect to changes that are not reasonably foreseeable and that are not within the broad original parameters of the program. And so states cannot knowingly accept terms and conditions on federal spending programs if they are not aware, if they're unaware of, or cannot reasonably foresee the conditions that are being imposed. So implicit terms, tweaking of a program within the original framework, very different story. The Bennett case says that that fits the clear statement obligation. But what do you do when you have these major program changes? So fine-tuning of the specific application of a program, that's what the Bennett case is about, within the program's original parameters is clearly a foreseeable implied term of a contract in a cooperative federalism program. But where there's a substantial modification of an ongoing program, where that program comprises a substantial component of the state's budget, as with the Affordable Care Act, and as with Medicaid, which tends to be the number one or number two state expenditure in every state. The only thing coming close is K through 12 education. With that, a substantial modification of an ongoing program, where that program comprises a substantial component of the state's budget, imposes unforeseeable financial obligations beyond what could have been expected when the states initially chose to participate in Medicaid. That's a problem, and that's what we have here. Next slide, please. So, Is the clear statement obligation satisfied by the Affordable Care Act? It's clear that there isn't a clear statement obligation. Is it satisfied? Well, the clear statement obligation is not satisfied if it applies at the contract formation stage regarding these additional conditions imposed on state Medicaid programs by the ACA. There's no way that states, when they signed up for Medicaid, could expect that their obligations would include covering folks up to 133% of poverty. It was a poverty medicine program. This is a major, major expansion beyond the contours of what was originally contemplated by Medicaid. If the clear statement is satisfied if it applies at the contract modification stage regarding these additional program conditions, well, you can argue that the clear statement obligation is satisfied. States are aware of their obligations effective January 1 of 2014. The question is this awareness at the contract modification stage sufficient to satisfy the obligation? Now, next slide, please. Now I'm going to talk about my view of the proper resolution of this timing issue. Additional protections are accorded under traditional contract doctrine at the contract modification stage because of the concerns involved with excessive leveraging within an ongoing relationship. And consider this example. This is a good way to think about it. This is an actual case. A fishing vessel goes out to sea. Once the ship is in the fishing waters, the crew demands of the ship owner a substantial wage increase. I think they asked for double their wages. This additional term is imposed at the contract modification stage and is not upheld because of the excessive leveraging that the crew had at that stage. The ship owner is faced with a series of unpalatable choices at that point. The court, therefore, did not uphold the increase in wages that was agreed to under those terms. Had the crew sought the same raise before setting sail, therefore, that is at the contract formation stage, the court indicated that a different result would obtain. That is to say, different rules apply at contract formation as opposed to contract modification. Now, next slide, please. We're in the home stretch here, folks. So is the clear statement obligation satisfied by the ACA? Well, again, to protect the integrity of state decision-making and its political process, a state must be able to understand clearly the financial implications of its decision to participate in Medicaid. That participation is constitutionally protected. States do not have to participate in Medicaid. They don't have to enter into Medicaid. But that understanding, in my view, must arise at the contract formation stage where the states can understand what the potential liability, expenditure liability will be down the road. If clear statement is satisfied at the contract modification stage, this allows for excessive leveraging, as in that fishing boat example, a form of bait and switch. And it allows an end run around the protections that are contemplated by the clear statement rule and that the constitutional protections that the clear statement rule is designed to protect. Next slide, please. This is the last one, I believe. But the objective of the clear statement rule is to give state officials a clear understanding of their financial or fiscal risks and what their obligations are when they sign up for an ongoing federal program. That's what the Arlington case says. It says you have to look at this from the point of view of the official who's determining whether to sign up for a program or not. You have to be able to judge, make a reasonable judgment about what the financial implications are for your state. That's the point of the clear statement rule. If, as the Supreme Court has stated, federal power to impose conditions does not, and again this is a quote from the Penhurst case, does not include surprising participating states with post-acceptance or retroactive conditions, then the clear statement rule must be applied at the time that states choose to participate in Medicaid. That standard should apply when A, the contract modification is substantial and foreseeable, and B, when the contract modification has a significant financial impact on a program that comprises a substantial component of the state's budget, such as Medicaid. Now remember, this double, what I call the twin substantiality standard, is designed so that this rule that I've advocated doesn't become the norm in all circumstances. Okay, next, I think there are two more, I'm sorry. So what is the appropriate remedy? Federal government cannot be required to maintain a spending program it no longer wishes to sustain, so that if it doesn't like traditional Medicaid, it should have the right, and it does have the right, to discontinue it. But in the absence of clear statement, at least at the outset, it cannot impose through contract modification contingent conditions that are substantially more onerous and that affect the substantial component of the state's budget. It cannot do this through contract modification. To achieve its goals, the federal government must recreate a contract formation situation where it can provide a state with a clear statement of its obligations under new Medicaid. So it can't achieve this through modification. It has to do it through some form of recreating contract formation. How does it do this? To recreate contract formation, the federal government must discontinue traditional Medicaid. It has to say Medicaid as we know it is gone. It is discontinued. And the states cannot be forced to opt out of this traditional Medicaid. This is a political choice that the federal government has made, and traditional Medicaid would no longer exist by virtue of federal law, so the states don't have to opt out of Medicaid. They just don't, there is no such program, and states will not be able to continue their participation because the federal government can discontinue it. But the accountability has to be right. And the political accountability has to be with the federal government for basically barring states from continuing their participation in traditional Medicaid. States don't have a choice. Their continued traditional Medicaid is precluded, and it's precluded by federal action, not by state action. Okay, now this is the law. Next slide, please. So what is the appropriate remedy? The federal government can achieve its goals under the Affordable Care Act by establishing this new Medicaid program. That is to say, requiring states that participate in new Medicaid that they cover folks under 133% of poverty. But this has to be done through contract formation. So states would be invited to opt into new Medicaid, not to opt out of traditional Medicaid. The traditional Medicaid will cease to exist. There's nothing to opt out of. States cannot be required to opt out of that through contract modification. Clear statement would then apply at the appropriate contract formation stage. States would be able knowingly to accept the terms of new Medicaid and covering persons with incomes under 133% of poverty. State officials would clearly understand the nature, scope, and magnitude of their obligations under new Medicaid so that they would, at the front end, know what they're in for, and they would then choose through the normal state political process to determine whether to sign up for new Medicaid, that is to say opt in to new Medicaid, and to exercise their choice whether to opt in or not and go through the political process of taking affirmative steps to opt into new Medicaid, but they would not be required to opt out of traditional Medicaid, which is the choice they now have under the existing Affordable Care. And that's it. Thank you.
Thank you so much, Professor. I think you've done an outstanding job of providing kind of some scene setting for the basic parameters of cooperative federalism, the kind of flow of funding from Washington to the states and the decisions made at the state level that ultimately affect budget decisions in the federal government as well, and tying that into the most pressing debate that we're having right now in that state-federal relationship on the Affordable Care Act itself. And with that scene set, I'd like to turn it over to Professor Hills for your reactions and to provide your own kind of spin on these broader state-federal issues. Professor Hills.
Great. Can you hear me?
Yes.
Excellent. I never know whether these computers actually continue to work, but tell me if my voice isn't coming through clearly.
So far.
Oh, excellent. So Jim's presentation on Medicaid was wonderful, and on the ACA, I would just make 3 constitutional points very quickly and 3 statutory points, which will amplify what Jim said and perhaps provide a little bit of extra information about the federal constitutional regime under which we now live. The 3 constitutional points are whether there are serious constitutional limits on Congress's power to dictate policy against state wishes. And it seems to me that one would want to think of three discrete areas usefully. One is in the area of congressional regulation of private persons. The second is in the area of spending, that is to say, not through regulation, but through the offering of money, primarily to states. And the third is in the question of the federal government's regulating states themselves, commanding states to regulate private persons. So in those three areas, are there any constitutional limits on Congress's power? In the first area, imagine that Congress is regulating private persons. Leave states out of it. Say they pass a gun control measure. They say that a certain category of persons can't possess firearms. Or perhaps they prohibit the growing of marijuana, even in your backyard, even not for sale. Are there any limits on that kind of federal regulation? And the short answer, just to keep things simple because I don't have a PowerPoint, is no. As far as I can see, there was a brief federalism revolution between 1995 and 2000 when the Rehnquist Court attempted to impose some sort of limits on Congress's power, regulatory powers. But by the early aughts, it became pretty clear that these would be, at most, very minimal limits. And this last term, the most notable point was the dissent of Scalia and Thomas in a case called Alderman. It was a dissent from a denial of cert by the rest of the court, where essentially Justice Thomas, in writing the dissent, said that the Rehnquist revolution in federalism, an effort by the Supreme Court between 1995 and 2000 to revive limits on Congress's regulatory powers, had been, and this is Thomas's words, nullified by lower courts, and that the U.S. Supreme Court wasn't doing anything about it. So that's the first category where you might expect to see some sorts of limits on Congress's powers. The key case undermining that revolution was a case called Raich, in which Angel Raich, a California resident, tried to grow marijuana for her own use to relieve pain of various diseases, and the federal government said that this was a violation of the Controlled Substances Act, and the Supreme Court upheld that exercise of the federal government's power, saying that if the federal government wants to regulate a general economic activity like drug trafficking, it can sweep up in its net as well non-economic activities like the growing of marijuana for one's own personal use. And in the Alderman case, the Supreme Court denied cert in a case where the possession of body armor by a convicted felon was criminalized by the federal government under a statute, section 229 of the Criminal Code, that says any possession of body armor or weapons by an ex-felon violates federal law, just so long as the body armor has traveled in interstate commerce. This is a fairly trivial limit on the power of the Congress to criminally prohibit the possession of weapons, or for that matter, anything else that traveled in interstate commerce. But the lower courts have consistently said that that sort of jurisdictional nexus suffices and to justify federal regulation. The Supreme Court denied cert in Alderman in a case where the Ninth Circuit held that that sort of jurisdictional nexus, that is to say the fact that the body armor had traveled through interstate commerce, justified federal regulation. The court denied cert. Thomas said that this essentially nullifies any kind of constitutional limit on congressional regulatory powers, and I guess I'd have to agree. And so I think that trying to look for any sort of limit on Congress's power to regulate private persons is not terribly helpful. There may be a few tiny enclaves where the states have exclusive regulatory powers, so probably it would be unconstitutional if Congress passed a law, say, regulating marriage all by itself. But they could probably regulate child support. And heck, they might even be able to regulate marriage if the partners had traveled in interstate commerce. So the degree to which there's any kind of sort of limit on Congress's regulatory power over private persons is pretty limited. That's my first constitutional point. The second constitutional point is whether there's any limits on the Congress's spending power. And here, the court hasn't been terribly encouraging on its willingness to impose limits. There is the idea, as Jim pointed out, that conditions on federal grants can't be coercive. But the court has never explained what that could possibly mean. And given that the alternatives are either to radically overhaul the spending system in ways that no one anticipates to protect state autonomy, or simply to declare that coercion doesn't exist whenever states voluntarily accept a clear condition, it seems to me that the coercion limit is largely meaningless. Keep in mind that whenever the federal government offers a state a grant that's financed by general taxation, in effect what it's saying is that unless you accept the conditions that go along with that grant, we are going to impose a special tax on your citizens. Because, of course, assuming citizens in every state pay roughly the same taxes, if you turn down grants financed with those taxes, your effective tax burden for the declining state, the state that declines that grant, is going to be higher than every other state. So it's a little bit odd to say that it's a voluntary condition simply because it's clear, given that the clear condition is simply a condition that you either give up your money or you accede to the condition. So yeah, I guess you could say it's voluntary because you knew what you were getting into. That's the same kind of voluntariness that occurs when a robber comes up to you and says your money or your life. The choice is quite clear. It passes the Pennhurst standard, but it's simply an offer that no one could refuse. So, unless the court is going to try to figure its way out of that conundrum, namely that every federal grant is really an offer to tax a state specially, to impose a special federal tax on state residents when state officials turn down the grant, I don't see the coercion limit as making a heck of a lot of sense or ever being enforced. There is a third limit on federal power, which the court has more vigorously enforced, and that's the limit that Jim referred to as the Anti-Commandarian Limit. The feds are not allowed to force states to regulate private persons. Now keep in mind that there's a lot of uncertain questions surrounding the nature of this ban on forcing states to regulate private persons. First of all, it might be the case that the feds can force states to provide information to federal officials. And so there's been a lot of question about whether, for instance, the feds could require police departments to provide information about the immigration status of persons in their custody. That's an undecided question. But this anti-commandeering principle is not terribly effective if you believe, as I do, that the power of states to turn down federal money is limited, given that the anti-commandeering principle is not violated by conditions on federal money, because there is the fiction that when states accept the money, they do so voluntarily. If you observe that fiction, of course, you're not violating the principle that you can't force states to regulate when you offer them a grant, the condition of which is that the states must regulate. So I actually think the hard constitutional limits on Congress's power to dictate policy against the states are either trivial or non-existent, which leaves the second question: are there statutory limits on Congress's power or federal agencies' power to regulate the states? And here's where I think all the action is. The court has shown a lot more willingness to construe both statutes and federal agency regulations narrowly to favor state power. And so in terms of statutory or regulatory construction, interpretation, it might be that states can squeeze out a little bit more freedom for policymaking than they can through constitutional prohibition. And here I just want to mention three sorts of limits. One is the limit on agency and statutory preemption of state law. Preemption is simply that which occurs when a federal law is enforced over a state law or regulation that conflicts with that federal law. The federal law is said to preempt the state law. And there has been some recent indications in the last 2 or 3 terms that the court is reluctant to construe federal statutes or federal regulations to preempt state law unless the statute is extremely clear that it is intended to preempt state law. A classic case from this term is the Mazda Motors case, which came down, I guess, a couple months ago. This is a case in which the National Highway Traffic Safety Administration had given automobile manufacturers the option not to put in a seatbelt, a shoulder-to-lap seatbelt, you know, one of those crossbody seatbelts, on the middle rear seat. I guess NHTSA, the federal agency, thought that it might not be worth it, and so they said to the automakers, look, you have the choice either to put it in or not to put it in. If you just want to put in a pure lap belt, that's your option. And the question arose whether this preempted states from using their tort law to hold manufacturers liable for not exercising that federally provided option to put in the shoulder-to-lap belt. And the court held that the regulation, which gave manufacturers this option, did not preempt state law. That states could hold manufacturers liable for not putting it in the belt, even though federal law gave them the option of to put in the belt. You know, and the opinion was a little bit interesting because one of the things Breyer said is that if we held otherwise, then every time you had a regulation that gave manufacturers some sort of option, state law would be preempted. And that kind of preemption is something that we don't think statutes contemplate, that kind of very broad elimination of state common law. So, you know, you do see from this term, from some cases last term that I'm happy to discuss, some sense the court is reluctant to construe federal law to preempt state law. Now, a second category where you may see some action, I think it's actually a difficult question, and this is one that Jim discussed in greatest length, is whether in construing the conditions that apply to federal grants, the federal courts will defer to agency officials, federal agency officials, or state officials. There is this opinion that Jim referred to, the Pennhurst opinion, that says that the conditions in a federal grant, attached to a federal grant, must be very clear before they will be held to bind state officials. And Jim has this lovely, you know, analogy to contract law. The idea is that there's some principle of voluntary acceptance that's facilitated by having only very clear conditions enforced against the states. The problem with the Pennhurst principle is that it is at war with a rival rule of statutory construction, which is that courts are supposed to defer to federal agencies' interpretation of federal statutes. So if, for instance, the Center for Medicare and Medicaid Services were to construe ACCA in a way that really burdens state power, this rival principle, which is usually called the Chevron doctrine after the 1983 case that announced the doctrine, the Chevron principle might say you've got to defer to the CMS officials, the federal officials. If the federal officials say that there's a limit on state power contained in the statute, and the federal officials make that limit clear with a regulation, or maybe even an interpretive letter, or maybe even just an adjudicative ruling, well, maybe the state officials have to back down. I think this is a completely open question. The court has shied away from it again and again. It has yet to explain who it's going to back. State officials who take federal money, or federal officials who oversee that money. And so that's a very live question. I'm not sure which will win, Chevron or Pennhurst. Now, the third and the last point I want to talk about is the coercion prong of the spending power, but not in the constitutional context. I want to talk about it in the statutory context. Suppose you have a statute that allows the federal government to sanction states that violate conditions in the regulations imposed by the federal agency or perhaps in the statute itself. How much of a sanction can be imposed? Can a gigantic sanction be imposed? Or is there some limit on the sanction? Now this is, I think, largely a matter of statutory construction, because I think if push came to shove and Congress clearly specified that states could lose a ton of money if they violated a condition, my suspicion is that the courts might very well back up you know, the Congress. But statutes are often ambiguous as to exactly what sort of sanction can be imposed. And it might very well be that the federal courts will favor the smaller sanctions. Here's an example of a case from the 90s, which was, you know, largely undecided. It has not been decided by the court. Suppose that a state, a school district, kicks out disruptive kids who happen to be disabled. Now the disruption is not from their disability. Maybe the kid's dyslexic. But in class they misbehave, and so they're expelled. Now, there is this obligation on states to impose an alternative education for disabled kids. The state officials might disagree with the federal agency as to whether that obligation extends to kids who are expelled for behavior that's unrelated to their disability. Well, say they lose on that, and the federal official's view is you do have an obligation to provide some kind of alternative education for these expelled kids. And suppose the courts back them up on that. The question still arises, how much money is the state going to lose for kicking the kid out? Judge Ludwig of the Fourth Circuit said, well, they should only lose the money that would go to that kid, right? Because they're only failing to provide an alternative education for one kid, so she'd lose money for that one kid and for any other kids who are expelled for whom an alternative education is not provided. The agency said, no, they should lose their entire grant under the relevant federal statute. You know, and that fight in the Fourth Circuit never went to the Supreme Court. But it seems to me that that fight will be critical in determining whether states can, in fact, resist agencies that try to sanction them for essentially following the state view of what the federal statute means. So I think those statutory limits are the important ones, but I'd be happy to, you know, listen to what other people have to say or questions people might have about either the constitutional or the statutory limits.
Great. Well, thank you both. And we've had some good questions come in, and I encourage anyone who has other questions to go ahead and put them up on the GoToWebinar platform. Well, the first one, you know, comes in regarding just the constitutionality of the Affordable Care Act itself. And certainly we've heard the discussion on the clear statement rule, but the individual mandate has been the element of the Affordable Care Act that's received the most press coverage. So the question is to both presenters, just asking you to simply handicap the court, or give a prediction of how the court will come out on the constitutionality of the Affordable Care Act itself. Will it rule against it based on clear statement rule and or individual mandate, or is it going to survive its constitutional challenge?
Jim, you want to take that one?
Well, I was going to wait for you, Rick, to go first. You want to go first, or do you want me to go first?
Well, I'll tell you, just last night I was debating this very issue with Akil Lamar up in Amherst before the Amherst Political Union. And on the other side were the two Ilyas, Ilya Soman and Ilya Shapiro. Ilya Soman's a professor at George Mason. Ilya Shapiro works at the Cato Institute. And I took the position, which I have taken on in various public settings, that the constitutional case against the individual mandate is exceptionally weak, and that I would predict that it'll be a 6-3 decision upholding the mandate, Alito, Scalia, and Thomas dissenting. That's the maximum that the opponents of the mandate will get. However, there's actually another issue, which is whether, in fact, the states have any standing whatsoever to challenge the individual mandate, because the device by which they got standing is really peculiar. They essentially said that the individual mandate cannot be enforced on our boundaries, and therefore the attorney generals of the states of Virginia decided to vindicate this interest in protecting their citizens from an individual mandate. But the court has never held that states have general standing to protect their citizens from federal laws that the private citizens might not like. And since the individual mandate hasn't even kicked in yet, and since you don't have a private citizen, therefore, who would have standing to complain about it, it seems really peculiar to say that an attorney general of a state would have some kind of derivative standing, parens patriae, about their citizens. So I can imagine, conceivably, that these challenges will be kicked off on standing. Incidentally, that's how the court has been handling a lot of federalism disputes, simply refusing to decide them by saying that the parties just don't have standing. That's how they resolved the free exercise case in Wynn this term. And likewise, they resolved the old Kuno case dealing with state subsidies, tax subsidies for local development. But my prediction is that the individual mandate will be easily upheld. I'd be glad to go into more detail, but I'd like to hear what Jim has to say.
Yeah, I think that it's, on the standing question, I think it's a more difficult issue. I think Virginia has a law, and I think some of the states in the Florida litigation have laws that would be invalid if the individual mandate is upheld. And so they obviously can't stand independently, but they do create an interest. And so I think standing may be overcome. There's also an independent taxpayer, the NFIB, which now has separate representation, and I think they have standing to raise that issue. So I'm not sure that standing is where it'll go. I think ultimately I had 3 areas of skepticism on this, and I have been persuaded out of 2 of the areas of skepticism, but not of the 3rd. My first thought was that this would be deemed to be a tax, and the federal government can justify a tax. I've now been persuaded by Judge Vinson's opinion that the federal government should not be allowed, and there's a peculiar drafting history here, should not be allowed to assert in court that it's a tax when they're asserting politically and in the language of the text of the statute itself that it's a penalty, not a tax, that you have to kind of have enough political gumption if you're going to defend it in court as a tax to call it a tax, and especially not to cover it up when the earlier drafts had the word tax and it was changed to penalty. So I think that Judge Vinson has persuaded me there. On the second question that I was dubious about is whether there's a distinction between activity and inactivity, and I was a little dubious about that, but I think Judge Vinson has made a reasonable argument that that's a line that can be successfully drawn if one is serious about establishing, as Rick said, there were these 2 cases, the Morrison case and the Lopez case in the 90s and then 2000, that this is a way of establishing a reasonably bright line of demarcation. Now, there's a question as to whether there's a basis for drawing that line of demarcation, but I think that it's certainly a reasonable position if one is looking for a manageable standard to restrain federal power under the Commerce Clause, that the activity-inactivity line is a reasonable line, and there have been no cases under Commerce Clause of inactivity being justified. The third area is the one that I think is the weakness of the opinion of Judge Vinson and the weakness of the state's case, and that is under the Necessary and Proper Clause. And I think that frankly, the litigation strategy, I have not read the brief. I have it right next to me, but I haven't read it yet. But the federal government's litigation has not been managed in a way that I would call typical of the excellence of the Justice Department. To me, the argument for the government that's the strongest is this, that the federal government has authority under the Commerce Clause to eliminate discrimination against those with pre-existing conditions. Now, people who do health policy know that this so-called guaranteed issue requirement will result in a death spiral or something like a death spiral for insurance. Why would you buy insurance if you can wait until you're sick and then buy it? And so in order to make that work, there has to be some stream of revenue in order to make that whole concept of guaranteed issue work. And the strongest argument in favor of the individual mandate is that it provides that stream of revenue against free riding, and so that it basically prohibits people from taking advantage of that. Now, I've said that there could, if you applied some less restrained form of review, one could say, well, there are alternatives. You can ask people to give up their ability to buy insurance when they get sick if they don't buy it before they're sick. But the Necessary and Proper Clause has not typically been a very heavy standard of review. It's been a very deferential standard of review. And so, to me, that's the strongest argument, that in order to make the guaranteed issue policy work, you need another stream of revenue, and the individual mandate provides that other stream of revenue, and therefore it's necessary. Now, there's some question of whether it's proper, but Judge Vinson's opinion, I don't want to get into the weeds on this, I'll do it if you push me, but I don't think that that has persuaded me as to why necessary and proper is not a sufficient source of federal authority. So that's where I'm headed. Now, on the other one, on the point that I was raising about the expanded Medicaid mandate, Judge Vinson really gave that short shrift. And I'm hoping, I know that the states have cross-appealed and that the Medicaid issue will be in the 11th Circuit, and I am now contemplating taking this presentation and turning it into an amicus brief so that this issue is properly presented to the 11th Circuit. I think this is a serious issue. I've done a little opinion piece on this. I think there, from a jurisprudential point of view, there are many reasonable, attractive reasons for the court to intervene on this basis because it's a form of interstitial intervention. It's what one of my teachers, Alan Spickle, talked about as a dialogue between the courts and the Congress. It doesn't forbid the federal government to enact or reenact the Affordable Care Act. They just have to do it the right way and abide by the clear statement principle at the time of contract formation. If they want to recreate contract formation, they can do this, but they have to take the political heat for basically killing off traditional Medicaid or allowing states the ability to choose whether to take on these new responsibilities or not. So I think properly understood that kind of an argument will get the Chief Justice plus the four that Rick has talked about, and I think reasonably Justice Kennedy as well. So I think there's a, I don't want to be Pollyannish about this, but I think that's the best shot, because it puts the courts into the modest mode of saying you can do this, Congress, but you have to do it right.
Thank you. Well, our next question is on a completely different topic. The basic question is regarding the relationship of the states and the federal government when dealing with international private law obligations, such as the implementation of private international law treaties that govern areas of traditional state power. Any thoughts from either of you?
I'm sorry, would you restate that, Chris? Would you restate that question?
Certainly. It's just your opinion on the relationship of the states and federal government when dealing with international private law obligations, such as the implementation of private international law treaties that govern areas of traditional state power. I myself am not an attorney. I know that within the state-federal dialogue, one area that is pretty low on the radar screen, but is just the implications of our international treaty obligations, things like the WTO, which impose obligations on the states in government procurement, areas like that, where our own federal government has gone out, created international obligations, legislated in the international domain, but in areas where states have at least shared jurisdiction.
Mm. Yeah, there was this case just this term. It's been argued on the treaty power and federalism. Unfortunately, it went off on standing, Bond versus United States, dealing with the Anti-Chemical Weapons Treaty, which, and so that's the last we've heard of this issue, before the Supreme Court. But the black letter law on this from hoary chestnuts like Missouri v. Holland and Belmont versus United States is that if indeed there is a international treaty or executive agreement, it doesn't have to be a treaty, that those legal obligations trump state law, assuming that they fall within the power of either the President to negotiate executive agreements or Congress, the Senate, to ratify a treaty. And that power seems to be defined entirely by your dancing partner. If you can get a foreign nation, a sovereign, to sign a treaty, the treaty can govern pretty much anything. And I think that's well settled. I may be wrong in the sense that the implications of Missouri v. Holland haven't really been explored by the court very well, and it would be nice if they'd explored it in the Bond case. The Bond case deals with thwarted love. A woman who was furious at her husband for cheating on her got some rather dangerous chemical powder. She was a scientist, and sprinkled around another woman's house on the doorknob of her car and this sort of thing in order to essentially kill her. And the feds went after her for violating the Chemical Weapons Treaty. Now, obviously, this really invades traditional state powers. This is crime. It's a crime of passion. It's not an economic crime. It's not part of an interstate criminal enterprise. So there doesn't seem to be any traditional justification for federal intervention. There is no interjurisdictional nexus. It's not like there was any element requiring that the powder have traveled in interstate commerce. So, it would be an interesting case for exploring the scope of the treaty power. And obviously, this application of the Chemical Weapons Treaty looks pretty silly. Alito, during oral argument, said, what if you put vinegar in a goldfish bowl? Would that be a violation of the Chemical Weapons Treaty? Because after all, you're killing an animal, and you're doing so with a chemical. But the court didn't discuss the issue at all. They discussed the question of whether there was standing, because that's how the Third Circuit resolved the case. But I'd say as matter stands now, there's not a lot of federalism limits on the treaty power, except that, of course, you need to have somebody to make the treaty with. I'll call that the dancing partner limit. You got to have some foreign sovereign power that's willing to sign an agreement. But if they sign an agreement, it seems to me that the contents of that agreement will preempt state law. What do you think, Jim?
Yeah, I think it's interesting. The only other piece I would add to that is that in a couple cases, including the Medellin case, the court has said that there has to be a private cause of action provision in the treaty in order to preempt state law or to even to apply. And so having a treaty alone is not going to be enough. There has to be a treaty that is embraced into United States domestic law. And that's a little bit of a change from what some of the earlier doctrine had been, but I think that's a pretty clear statement now that it's a two-step process. The first is, what does the treaty hold? And secondly, has it been, either in the terms of the treaty or through other forms of legislation, been embraced to U.S. domestic law? And then if the answer to that is yes, it's intended to have this effect, then I think it does have preemptive power. This was the subject of, I believe I'm right on this, Rick, back years ago in the 50s, of the Bricker Amendment, which was designed to overturn that, and never was enacted in
Yeah, and notice that that's just another example of where the constitutional limits are trivial, but the statutory construction limits, if you will, are pretty significant. Because, of course, Congress could easily make a self-executing treaty just by saying so.
Well, just to react to that, since you are both law professors, and as we all know that it's state bar associations who determine the standards by which you can practice law in your state. Meanwhile, we're negotiating trade agreements around the world, bilaterally, multilaterally, trade partners who want to have better access to our own service market. So let's say the federal government goes out and it inks a new trade agreement with some of our Pacific partners, as we're negotiating right now, and for some reason they get the American Bar Association to go along with it to set a federal standard for the practice of law in the context of the agreement, so that we have a reciprocal agreement on the practice of law between our trade partner and ourselves that sets the basic standards for the practice of law. How would that interact with the 10th Amendment powers in terms of states being able to regulate anything that isn't specifically enumerated within the Constitution, and our historical tradition of that being something regulated at the state level?
Well, of course, explicitly doesn't occur anywhere in the 10th Amendment. And that's what was pretty important when the court in McCulloch v. Maryland said that Congress's implied powers can be construed broadly. So I would think that would raise no trouble whatsoever as a matter of constitutional limit. It would be very easy for Congress to preempt, either with a treaty or with a plain statute, all occupational regulations. And indeed, even the federalism cases from 95 to 2000 left Congress's power to regulate the economic sphere, and certainly occupational licensing, completely untouched. So although it is a traditional state power to regulate the occupations, just as it's traditional state power to regulate the insurance market, no one has the slightest doubt that with a stroke of a pen, Congress could abolish state insurance regulations, preempt them entirely, and Congress could abolish occupational regulations. The Federal Trade Commission is constantly trying to limit state occupational regulations because they think, correctly I believe, that state occupational licensing is used for outrageously protectionist concerns. And I will say that the New York Bar is one of the most aggressively protectionist organizations in the country. And so agencies, let alone Congress, are often attacking bar regulations. But no, I don't think there would be the slightest problem as a matter of constitutional concern. Now, of course, you're going to have a treaty, as Jim says, that specifically states that there's a private cause of action against state occupational licensors, or that there's otherwise a self-executing treaty. And if you can get that treaty, it's the law. And that would be a 9-0 decision.
Yeah, the only caveat I would add, I think that's generally right. I think there's a question about practicing in state courts where some states have taken the position that the state judiciary branch has supremacy over the practice within the state, and whether or not that would be a sphere of state autonomy that somehow a court would protect in some way is still an open question. I think that occupational licensure, if you view legal licensure as just any everyday garden variety occupational licensure, I think that Rick's analysis is right. But I think there may be a kernel of state autonomy, the way that some states have treated state court authority to govern practice within its jurisdiction, that might invoke certain limits on the scope of federal power. And I think that it's hard to, without having a case, it's hard to see whether that would be developed. But I wouldn't forecast 9-0 on a hypothetical that might be developed that would intrude upon state courts' authority to govern themselves.
I'm sorry, please go ahead.
Very quickly, the odd thing about state autonomy doctrine is that there's one branch of the state government that has not been protected by the court's line of cases in state autonomy, and that's the state courts. And so state courts actually can be commandeered to hear federal causes of action. So it certainly would be interesting if the U.S. Supreme Court reversed itself and said, well, no, state courts' power over private attorneys as officers of the court is such that if the feds took over this business of licensing attorneys in state court, that would violate state autonomy, given that the very state judges don't have state autonomy to resist federal mandates.
That's a fair point. That goes back to the early case of Martin versus Hunter's lessee, in which the autonomy cases, the more modern autonomy cases, have distinguished that because there is a provision in Article 3 of the Constitution that gives the U.S. Supreme Court authority to hear cases arising under the constitutional laws of the United States, and therefore it's an exception to it from this anti-commandeering principle I was describing. So I think Rick has a good point there. I'm just saying cautiously, it kind of depends on what kind of intrusiveness there would be on the ability to practice within a state, not to give states autonomy in their decision and their ultimate decisions. Those are reviewable.
Well, thank you both. And as a broadly related question, we have a question regarding just the kind of the state of play of the 10th Amendment itself. It's coming from a state where one of the state houses has recently passed a sense of the House resolution regarding the need to strengthen the 10th Amendment. There have been a lot of those types of non-binding sense of the state Senate, sense of the House resolution in the last 3 months or so. So maybe just two of you could just give your own observations as to how the court will treat the 10th Amendment going forward.
Well, Chris, what's the context again? I'm sorry, I didn't follow the example that you.
Sorry, the context is just broadly there have been almost identical resolutions passed in state houses and state senates over the last 3 months. It happened last year too in the state legislative sessions in 2010, but they've really accelerated in 2011. And I don't have one of them in front of me, but they basically say they basically chastise our own Congress to pay attention to the 10th Amendment. And it's a belief that Washington is increasingly encroaching into areas of state responsibility. And the nature of the question is, where do you feel that the court is coming down right now in terms of using the 10th Amendment as a vehicle to protect states from action by Congress?
You know, I guess I can take that first. There has been a tradition of kind of attempting to put some teeth into the 10th Amendment to establish limits on the scope of federal power. And a modern high watermark of that was the 1970s case of National League of Cities against Austerity, where the court put some limits on federal power. Then that was overruled in the Garcia case 9 years later, in which the court adopted a view that basically said that there are only political restraints upon the federal government. If there's a source of authority for the federal government to act, then that's sufficient. Then you have these two anti-commandeering cases from the 1990s, in which the court is attempting to resurrect limits on federal power and the Anti-Commandeering Principle, at least in the Brady handgun case, the United States versus Prince case, it does suggest that this is an affirmative limit on the scope of federal power, that it cannot commandeer states. It has not really clearly decided what commandeering is, as Rick indicates, but I think it's a reasonable interpretation of those cases that anti-commandeering is a limit on federal power. My own view is that if the court is going to take federalism seriously, it's going to have to develop these affirmative limits on federal power, such as state immunity under the 11th Amendment, and the court has developed a pretty robust doctrine of immunity, and the anti-commandeering principle. I view the clear statement rule as a form of affirmative limit on federal power, and that's the presentation I made builds upon that clear statement requirement. I view that as affirmative limit. But if the court is going to provide legal protection, and many oppose this, but if the court is going to provide legal protection for state autonomy in some way, it's going to have to develop manageable standards that are in the nature of affirmative limitations. And that's why I'm drawn to this idea of putting some teeth into the clear statement doctrine. It's a manageable and reasonable way of affirmatively limiting the scope of federal power to engage in these kinds of bait and switch techniques that the Affordable Care Act basically is.
Yeah, I agree with everything Jim said. I would just make one very simple point. There's huge confusion about the meaning of the 10th Amendment because there are two doctrines that are connected to the 10th Amendment, and they actually are quite distinct. One doctrine, or one principle, is the principle of enumerated powers. That principle says that Congress has limited power to regulate private persons. And that doctrine is based upon the 10th Amendment, because the 10th Amendment simply says that the states shall regulate private persons in all cases where Congress doesn't have an enumerated power. Indeed, that's the clearest meaning of the 10th Amendment. The 10th Amendment simply says that in construing Congress's powers, make sure that the states get everything that's left over. And so if Congress doesn't have a power to regulate private persons, the states get that power. Now, when most people talk about the 10th Amendment, in the legal world, they're not actually talking about the doctrine of enumerated powers. But it's important to understand that when lay people talk about the 10th Amendment, I think they often do mean the doctrine of enumerated powers. So these state legislatures are often concerned about congressional intrusion in the regulation of private persons, laws that regulate the possession of handguns or homegrown marijuana, or all sorts of, marriage, family law, tort law. And the prospects for that version of the 10th Amendment to be revived are, as I said when I made my initial remarks, very small in this court. The Roberts Court does not seem terribly interested in putting limits on Congress's power to regulate private persons. Now, there's another meaning for the 10th Amendment, and that's one that Jim refers to, I think. And I think that that's quite a slang meaning, because the doctrine of state autonomy really has nothing to do with any textual provision. It's not linked to the 10th Amendment especially. I mean, if you want, you can tie it to the 10th Amendment, but you could tie it to just the spirit of the Constitution just as easily. This is the principle that Congress can't regulate the states themselves. That's what state autonomy means. It's quite distinct from enumerated powers. It's not about Congress's power to regulate private persons. It's about Congress's power, or lack thereof, to regulate the states. And as Jim pointed out, there is this one limit on Congress's power to regulate the states. The states can't force, the Congress cannot force the states to regulate private persons. And so to the extent that you have a federal mandate commanding a state to regulate a private person in some way, you could have a problem that the courts would be willing to enforce. But that's a fairly limited restriction on Congress's power. Congress can regulate the states when what Congress is doing is regulating the states pretty much in the same way that they regulate private enterprises. They can force the states to pay minimum wage, observe labor laws, observe environmental laws, and the courts will impose very little limit on those sorts of congressional regulations of the states. So it seems to me that there's not a heck of a lot to of a prospect that the U.S. Supreme Court will impose much of a limit on Congress through the 10th Amendment, understood either as enumerated powers or state autonomy. Maybe some limit on state autonomy.
Let me add a point to that. I mentioned the Affordable Care Act. A sleeper issue in that challenge is the expanded Medicaid. There's another sleeper issue that can only be resolved by the Supreme Court, and the states have basically challenged the ability of the federal government to require states as employers to comply vis-a-vis their employees with the Affordable Care Act. And so this goes back to the case I mentioned from the 70s, the Austerity case, which was overruled by the case from the 90s, the Garcia case. And basically the states, when it gets to the Supreme Court, will be asking the Supreme Court to overrule Garcia or modify Garcia and return to the regime of Austerity. That's another sleeper issue. Now, when Garcia was handed down in the 1990s, the dissenters, what I would call Southmore in 1985, yes, there was the dissent, a very strong dissent that basically I call the South will rise again dissent, in which the dissenters said as soon as we get our 5 votes, we're going to overrule this. Well, it's been 25 years and it hasn't happened. But that's one of the sleeper issues in this case. This is going to clearly present the question whether Garcia itself should be overruled or modified, and of course only the Supreme Court can do that. So that issue was just, just sleeping there. The district judge can't do anything. The Court of Appeals can't do anything on it. But if it gets to the Supreme Court, it'll be interesting to see if there are 5 votes to overrule or modify the Garcia case. And I don't really have a good feel for that. But that's also in the case that the states as employers have an autonomy interest that was respected by Austerity and was not respected in Garcia.
Yeah. Now, just on that point, I would bet very large sums of money, if if somebody were willing to take me up on it, that the court will never give states immunity from mandates that private corporations have to observe, for a very practical reason. The competitive advantage that state enterprises, say state hospitals, would get if they had immunity from mandates that private enterprises had to observe would be so huge that the National Association of Manufacturers, NFIB, Chamber of Commerce would go berserk. And you can imagine that states would exploit that immunity quite aggressively. They could leverage it to have state-owned enterprises really threaten private-owned enterprise. And I think that was largely the reason why the court started to trim back on usury long before usury was decided. Because, of course, the doctrine of state autonomy didn't begin with usury. It began with Collector v. Day in 1872, which gave state employees immunity from federal income taxes. And between 1872 and 1946, the court cut back on that immunity precisely because private businesses said, hey, why are states getting all these immunities from federal taxes and federal regulations that we don't have? They're putting us out of business. So I can't even imagine the Roberts Court saying, oh, we're going to give state-owned hospitals or state medical personnel some kind of immunity from federal mandates that all private doctors, private insurers, private hospitals have to observe, because the very constituencies that are most in favor of federalism in many contexts would go berserk and say that's an unfair competitive advantage.
Well, thank you. Well, we've got a question that relates to the clear statement doctrine and commandeering. It must be from someone who serves on a transportation committee. Basically, the question relates to the points you make on the Affordable Care Act, and in terms of the change in the contract between the federal government and the states being made midstream, and the limits on the federal government in making those kind of changes. How would that apply to conditions on state transportation funding? It's another element of our cooperative federalism relationship. Certainly we have the case history of the federal government changing the drinking laws across the nation by placing conditions on state transportation funding, but that's only one example of many conditions that have been added to state transportation funding over the years in efforts to get changes to get states to play a role in regulating conduct in jurisdictions. How does that play out in a constitutional context?
I don't understand the exact nature of transportation funding, whether these are relational contracts or whether they are new contracts for each period of time. But if they're ongoing in the same way that Medicaid is ongoing, then the question under my approach would be whether these are substantial modifications, A, and then B, whether they affect substantial unforeseeable aspects of the state budget. And I don't know what the magnitude of transportation is, but I don't believe it's anything like Medicaid or K through 12 education. But I'd have to understand a little bit better how the federal government and the state government interact in state transportation. Certainly the Dole case was deemed to be a small potatoes, 5% of highway funds, and it would not be a substantial portion of the state's budget. So I don't know what conditions the questioner is talking about, but I think it would be hard to imagine that it would be in the same ballpark as the Medicaid expanded aspects. Now, there are also similar issues, I'm told, in environmental regulation as well. And so I think the argument against my approach is that this will open to a case-by-case adjudication about how substantial the changes are and how substantial the implications are. And my bright line rule is not all that bright. But I think that my sense is that if the court finds the category to be of substantiality to be appropriate, the place to start is Medicaid, and then to see how much in similarity there is between the Medicaid relationship and the changes in the Affordable Care Act as compared to these other areas of transportation and environmental law.
Thank you. Anything to add, Professor Hills?
No, the only thing I'd mention about conditions, and if Jim has any thoughts on this, I'd be interested. You have two kinds of conditions on federal money. Cross-cutting conditions apply to many different grant programs simultaneously. So Title VI says if you get federal money, you can't engage in racial discrimination. Section 666 of the Criminal Code says if you get federal money, recipients of federal money or participants in federally funded programs can be liable for corruption, federal crime of corruption, and so forth. And the court in the Sabri case, for instance, upheld those kinds of cross-cutting conditions. Now, I don't know how Jim's theory would apply to a cross-cutting condition. If the federal government passes a new statute saying that for all federal money, including transportation money, you must observe the Davis-Bacon Act, or something like that, which requires you to pay the prevailing union wage on federally financed programs. Would all of a sudden every single statute affected by that cross-cutting condition have to be renegotiated, or what? Because there are a lot of Title IX, Title VI, Section 666, the Davis-Bacon Act itself. There are a lot of conditions just apply to federal funding generally that aren't specific to a peculiar grant. Transportation, by the way, is very much like this. The biggest problem that states and localities find with financing infrastructure, including transportation, is there are a lot of cross-cutting mandates like the Davis-Bacon Act that hugely increase their labor costs. And I'm just not sure how Jim's theory would apply to those kinds of cross-cutting conditions.
Well, thank you. Well, we have one last question, and to give you context on this question, another element that's been echoing in state legislative chambers over the last 3 months or so, there have been, I believe it's over 20 states to date who have had a resolution on something called the Madison Amendment. It's basically an effort by some outside groups working with state legislators to try to get states to pass a simple resolution calling for an Article 5 constitutional convention with a limited scope to create a new constitutional mechanism that would allow states to call a constitutional convention that would be specifically focused on one particular issue. In this case, it's about expanding 10th Amendment powers. This is perhaps beyond your field because this isn't something that is part of the court's activity, but it is certainly something that's echoing out in our state chambers, and I think that's what's motivating the question. And that's simply, do you have any opinions as to whether there's a role for the states to use their constitutional convening power to change the nature of the state-federal relationship?
Well, Rick, do you want to try that?
Yeah, I mean,
I'm going to have to break away for a minute here.
Yeah, sure. Yeah, I'm going to have to bail pretty soon, but you know, the states have petitioned for limits on federal power since 1798 with the Virginia and Kentucky resolutions. It's a very time-honored tradition of states petitioning for a constitutional convention to limit federal power. And so the Madison Amendment is one in a long line of literally hundreds of amendment attempts by states. You know, and it's properly named after Madison because he, of course, authored the Virginia and Kentucky resolutions, which were an effort to amend the federal Constitution and calling upon other states to join in amending the federal Constitution to outlaw the Alien and Sedition Act, a federal statute that at that time was believed to exceed Congress's powers. So sure, of course they have the power to you know, pass such a resolution. Here's what and by the way, I'd be strongly in favor of that because I just don't think of such a political method for defining more carefully Congress's powers. Certainly, I'm somebody who thinks that Congress's powers have been overextended, and yet that I believe the court will never play a robust role in enforcing those limits. So, you know, having some kind of political forum where the limits could be discussed more freely, more creatively, less legalistically would be great. But here's the problem. A call for a convention limiting federal power is not a convention on what you call one specific issue. It's a convention on thousands of issues. It's a convention on everything from, you know, temporary assistance to needy families, to ACA, to, you know, federal military powers. And so in some sense, you're going to have to redraft the single longest section of the Constitution, Article 1, Section 8, which has 18 clauses and was already quite detailed in 1789. In order to seriously limit federal power, you're going to have to really engage in a complicated drafting exercise, and the number of issues that are implicated are literally innumerable. So don't think this is going to be an easy convention, but more power to you. It would be a very interesting convention, and anybody who teaches federalism would want to have a front row seat.
Thank you. Any reaction to that?
No, I think, Rick, I have nothing really to add to that.
Well, with that, I want to thank you both. I think this is a fascinating discussion. I myself have learned a lot. We've had other forums at our meetings where we've had debates on the constitutionality of the Affordable Care Act, where we've had broader discussions